The Honorable Court of Appeals of Tennessee is now in session.
Thank you, Madam Clerk. Welcome to the attorneys to the Tennessee Court of Appeals. Your panel today consists of Judge Fryson, Judge Davis, and myself, Judge McClarty. You've already been told this probably, but I'll say it again. During these proceedings, if there develop any difficulties on you that you notice, please let us know immediately, and so it can be corrected. Also, your case, you present your case as if you were in the court, the physical court building and courtroom itself, except you will not need to stand to make your presentation. Madam Clerk, are there any preliminary matters?
No, Your Honor.
Will you please call the case for us?
Edna Gergel versus James Gergel.
For the appellant, you may proceed.
Thank you, Your Honor. Good afternoon. May it please the court. My name is Mandy Hancock, and I represent the appellant James Gergel in this matter. This was a case of one thing leads to another. As I'm sure you're aware, this was a case that spanned over a period of approximately 5 years, multiple days of trial, and a multitude of witnesses. What began that litigation was at the initial stages of the case, the wife had requested an expert because of the husband's deteriorating mental health. And she was also given an order allowing her to get access to the husband's medical records. This snowball began when the wife retained the services of Dr. Peter Young, and Dr. Peter Young testified. And that's what kind of started the snowball effect and where this case started to grow and get out of hand. As you all are aware as well, he was the first expert in this case, and he also committed perjury during his testimony. So after that, and after he testified that the husband could cause or could be harm to this child, then the husband was put in a position that he had to get an expert to testify in this case as well. And this snowball increased gradually over the years till it became a 5-year intense litigation case, plethora of unnecessary filings, 7 days of trial, post-trial motions, and now this appeal. So we go from Dr. Young to the husband hiring Dr. Grello, and then the court stops and says, wait, I want an expert, and that's going to be Dr. Kronk. Well, that never happened for whatever reason. I don't think he had the time or couldn't take the case. But for whatever reason, we proceeded forward and started this trial on May 22nd of 2019. And at that point, the court did not elect to stop the trial so that the court could get its expert, and the wife did not ask to continue the trial so she could get a further expert. And then what happens is that on May the 22nd and the 23rd, the husband takes the stand and he testifies in this case. We don't get done with the trial in those first 3 days. So therefore the case is continued to July of 2019. And I think it's important to note that prior to that time, we had filed Dr. Young's deposition with the court. That was filed a little over 2 months before the trial began. And in filing Dr. Young's deposition, that also included as exhibits the depositions of a doctor called Dr. Fisher. He was the psychiatrist who was treating the husband for several years. So those 2 depositions are in the court record about 2 months before the trial starts. Then a few days before the trial starts, the deposition of Dr. Grello is filed. She was the psychologist who was hired by the husband. So after those first 3 days of trial in May, we get to July of 2019 when we had rescheduled the trial so that we could come back and finish. At that point, the trial court raises concerns based on these depositions that are filed by these experts and based on what the court had observed the defendant's testimony back in May. And at this point, the court is concerned if the husband is competent to testify. So that becomes the issue. And Why that was done in chambers, I don't know. It probably should have been done in open court. But the court says that the court's going to appoint its own expert to tell the court if the husband is competent to testify. Because at that point, none of these experts had ever been asked that question. So at that point, we are mid-trial and the court's stopping and they're appointing its own expert. But the case even gets bigger because, and if you'll notice in a lot of the pleadings, there are orders that are submitted by the wife's counsel and only signed by the wife's counsel. There was a lot of issues with getting agreements on things that had happened in court, and all the other orders that were submitted to the court, they weren't signed by the court. So therefore the court said that that was not part of the record that goes to the Court of Appeals. But there is a reference in the motion that I had filed to strike the testimony of Dr. Alexander about the order that I had filed based on this July hearing that differed from the order that the wife had filed, which was ultimately signed by the court. Because in that order, it tells the court's expert, who ultimately becomes Dr. Sidney Alexander, not only should you test him for competence, but also test him for malingering. And also, once you issue your report, the attorneys can contact you, ask you questions, submit additional documents. So that's where a lot of the issues had arisen in this case. And in some ways, the order that was submitted that appoints Dr. Alexander is the same order that was submitted that appointed Dr. Kronk, and he's the expert who never actually did an evaluation for whatever reason. But it's clear from the final decree, and I think it's also clear from the wife's brief, that Dr. Alexander was not only the court's expert, but was later retained within several days of starting the trial back in November to become the wife's expert. So that's one of the main issues that we take on this appeal, is whether or not the court can, one, appoint an expert mid-trial once the trial has already begun, and then two, can that expert also become an expert for one of the parties? And also within that issue is, can the court, well, first off, you have a scheduling order that says by these deadlines, both parties are to submit who they're going to use as an expert. Well, that deadline was obviously missed because we go back to trial in November and all of a sudden the court's expert is also the wife's expert. And not only that, he completely changes his testimony from the report that he has issued to us. And he also admits under oath that he did not inform myself nor the guardian ad litem of his change of this opinion. So these are all things that are happening. So it's devoid of any discovery that I have sent asking, hey, who's going to be your expert? Tell me what they're going to say. That doesn't get done. It's also devoid of the Tennessee Rules of Civil Procedure that ask you to disclose any expert testimony that you're going to use. So that's one of the main issues that we take up on this appeal, because Dr. Alexander issues a report that is very consistent with what the other experts say about the husband's mental health. And I have a conversation with him, and that is on the record as well, and that's during his testimony. I have a conversation with him the Friday before the trial resumed on Tuesday, and everything is still consistent with what's in his report until we get to court, and then that changes that day. So at that time, I asked the court to please stop the testimony to give me further time to cross-examine him, which is overruled, and it's allowed for him to proceed forward. And then, so the next day I file a motion with the court to please strike that testimony for the reasons that are set forth in that motion, and a lot of the reasons that I'm discussing here today. And that testimony became important because not only did he testify about the husband's competency as a witness, but he also testified about the husband's ability to work, the husband's ability to parent, the husband's credibility. That all really factored in and weighed a lot on what the court decided in this case. So that's kind of the main issue that we took up with this appeal, was Dr. Alexander's testimony, which, going back to my snowball I was talking about, how this case just expanded, and how because of Dr. Young, we had to get further experts involved. And that leads to the decision that the court made to award the discretionary cost and the attorney fees in this case, which was very large. When you add up the total of the discretionary cost and the attorney fees alone that was awarded post-judgment, it was $120,637.05. That represents 25% of the marital estate that was granted to the husband in this case. And then the court also found this dissipation issue.
You have your time for rebuttal. Thank you very much. Yes, sir.
Good afternoon, Your Honors. I'm Donald Caparella, representing Edna Gergel in this case, along with Kimberly McDonald. Now, the opposing counsel in their brief and in the argument today spent most of the time talking about this expert testimony issue of Dr. Alexander, whether the trial court erred or actually abused her discretion in not striking his testimony. But the question that should be most important to this court is, what does that even matter in this case? What issue does the Dr. Alexander's expert testimony even relate to as far as the issues that are on appeal? And the only issue it could possibly relate to is whether or not the trial court abused her discretion in finding that he could actually work and he wasn't disabled. But that issue actually doesn't even matter either, because the alimony decision by the trial court was rooted in need and ability to pay and the husband's fault. And in alimony decisions, which again is an abuse of discretion standard review, the primary issues are need and ability to pay. And the trial court found that the wife's need was, that the wife's income was approximately $11,500, while she had over $13,800 in expenses. So therefore, she had no ability to pay any alimony because she was underwater on her side. The trial court also found that husband's expenses, after she set aside things that she thought were unnecessary, that he didn't even have expenses for, was essentially equal to what his disability income was. So the trial court said that he didn't have any need based on his disability income, and she didn't have any ability to pay, and plus he was at fault for causing the marriage to end because he committed verbal, emotional, and physical abuse. So you don't even get to the question about whether he can work or not, because the trial court didn't even impute any income to him in measuring the income and ability to pay. So the court accepted that his disability income was the $4,187 and looked at his expenses that were essentially the same and didn't even impute any income above and beyond that. The court also factored into her analysis in rejecting any alimony the fact that the husband received over $460,000 in marital assets. So I'm sorry, Judge Davis, did you have a question?
Yeah.
Okay. So under the abuse of discretion standard review, the alimony decision should be affirmed because there was no abuse of discretion. Now, we also submit that the entire issue of the expert testimony, which I think only could relate to that issue, whether he can work or not, has been waived in this case because their issue statement is as follows: whether the trial court erred in appointing and or allowing certain expert testimony. So we don't even know from their issue statement which expert they're talking about. The trial court also made a specific finding when she appointed Dr. Alexander to investigate whether the husband was competent to testify. She made a specific finding that husband and his counsel deferred to that decision, didn't even object to him being appointed. And then when he issued his report, wife sent an email and said, I want him to do more work by looking at more things because I don't think he's looked at all the records. No objection was made to that email. And the trial court was so persuaded that the email meant that the opposing side had no surprise in any of that, that she made it, incorporated it into her order denying the motion to strike. But just to remedy any prejudice to opposing parties, to husband, the trial court expressly ruled, and this is page 439 of the technical record, that the defendant, husband, is given the opportunity to cross-examine the witness that they say they were surprised in his testimony on the last day of trial, or do it by deposition and submit that on the last day of trial, and they did neither. So they didn't even afford themselves the relief that they got from the motion to strike by taking by doing the cross-examination of Dr. Alexander and try and rebut his finding that husband was a liar, an exaggerator, and a malingerer. But my main point on Dr. Alexander is that it can only affect an issue that is not even before this court anymore as to whether or not he can work, because the alimony ruling can be affirmed by just considering the need and ability to pay and the husband's fault, and the fact that the husband has not appealed any of the findings of fact that the trial court made, analyzing all the factors of the alimony ruling. Now, the property division issue, I'd like to talk about it as well. Again, we have our waiver argument on that because basically the only issue prevented on appeal on property is whether the trial court erred in the division of marital estate. That, under the law that I cited in my brief, is not enough to preserve that issue. But even if you want to get into the merits of that, the only property division issues that they are challenging, because remember, the trial court awarded 50-50 to each side, 50.02, 49.8, so essentially 50-50 of the marital assets. So they're challenging two dissipation rulings. The first one was a dissipation ruling of $20,000 against the husband. And the proof of that was that after the wife separated and left the home with the child, husband started taking, over a several month period, $25,000 in cash out of a joint account. So it was taken during a time that there was difficulty in the marriage, which is one of the elements of dissipation. And it was taken in cash. Husband had a history of using an enormous amounts of money for his own enjoyment that would not benefit the marriage, such as accumulating 14,000 books, all these toys and games and stuff that were not for the child. And he could not, despite being challenged at trial, explain what he did with that cash at all. So we believe the trial court correctly made the dissipation ruling. But the more important issue now that we're on appeal is Your Honor's standard of review. Your role in considering a marital property division is whether it was overall equitable. And you're not, to quote from one of the opinions, you're not supposed to tweak a property division. A $20,000 dissipation finding in the context of a nearly $1 million estate is essentially a 2% finding going the other way. So no one would argue that a 52-48 division of property is inequitable. So even if you gave them the benefit of the doubt and found that the entire dissipation ruling was an abuse of discretion, you'd still be well within calling this overall distribution an equitable distribution. So the second issue, the dissipation issue as it relates to husband's contumacious conduct and misconduct during the entire case, is also a dissipation finding, because the trial court, for the same reasons I've just described, said that husband caused 5 or 6 continuances in this case. One of them by lying to the court found about whether he had a medical procedure in the future that caused the case to be continued. The court found all kinds of discovery abuse. The court found many, many orders that the husband didn't comply with. And husband was paying his attorney out of joint marital funds. So the trial court appropriately found another $45,000 in dissipation. And the other side claims that there was no basis for that, but the court made very specific findings that she looked at the entire amount of attorney's fees in this case, which were several $100,000, and tied 45,000 of those attorney's fees to those specific actions that the husband made. After all, the court did a 51-page order with numerous factual findings in this case, and none of those specific factual findings are actually appealed in this, are challenged by the appeal. So therefore, they are essentially assuming that they're correct. And without that, you can't get an abuse of discretion, which requires a clear violation of the law, and they don't even have a claim that the court violated the law. So, again, overall, in order to get an inequitable property division under your standard review, which is abuse of discretion, you still have to have the overall distribution to be inequitable. And even if you add the $45,000 in dissipation award with respect to attorney's fees to the $20,000 for the cash that he was taking for himself, you still get maybe 5 or 6% of the entire marital estate. So again, to grant them any relief in the marital property division would be tweaking a trial court's property division, which your honors state that you don't like to do unless it's overwhelmingly necessary to do so, and it's not in this case to do so. Now, the last sort of property issue they raise is they have about 4 sentences in their brief with no case law cited that the trial court erred and erred in giving each party their pension. Wife's pension was about, I think, $1,800 a month, 16 years from now when she retires, and husband's pension was about $1,200 a month or something like that. They were not that different in size. They were both over 1,000. Hers was closer to 2,000. Hers was closer to 1,000. And the court just gave him his pension, gave her her pension. And again, they're both 49 years old. They're not going to retire for 16 years. And they argued that the trial court should have split that individual property right equitably. However, that's not the way it works. It's the overall division that has to be equitable. And even if you leave it exactly as it is, you're not going to have an abuse of discretion for the trial court to give each side their pension amounts, especially since neither party will reap the rewards of those pensions amounts for at least 16 years, assuming they live that long, and everything goes according to plan under the pension rules. So you should affirm the trial court's property division as not being an abuse of discretion. Now, I'll just go through the last couple of issues here quickly. The only issue as to custody that the husband has appealed is the decision-making authority the major decision-making authority going to the mother. Your Honor, the trial court found that the mother was the primary custodian in this case and only gave father approximately 22 days in visitation, no overnights, no visits that were not in a public place. And the only argument they're making about that is that the father had a relationship with the child. But there's not a single case they can cite where somebody who has 340 days parenting time is the primary custodian and has all the other factors weighing heavily in their favor, that it would be an abuse of discretion to give the mother the major decision making. So that's essentially a frivolous argument. Now, the trial court also awarded attorney's fees under 36-6103C, only related to the issue of the appeal of the custody issues, because that statute allows when parties fight over the custody decision, the parenting plan, that statute allows the trial court in its discretion to award attorney's fees, which the trial court did. So we think that since they don't appeal the amount of that or the reasonableness of that, they only appeal that husband was actually, the wife was not actually the prevailing party. Well, wife was the prevailing party in so many ways. Number one, husband asked that he be made the primary custodian, and he got 22 days with no overnights and all visits in public place. He won so many other issues on that subject as well. And the only issue they appeal is the major decision making. So trial court did not abuse her discretion in awarding attorney's fees. But we also are asking as relief for ourselves in our appeal that under that same statute and under that same authority that you award attorney's fees as it relates to custody, because the trial court tailored her $65,000 attorney's fees ruling out of many hundreds of thousands that went on in this case solely to the custody issue. So we ask that you give us attorney's fees for the work on appeal also related to the custody issues. And We also have a frivolous appeal argument because of all the waiver issues, which my brief, I'll just leave standing for that, because you can't respectfully have such overbroad issue statements and preserve your issues on appeal. Plus, there are problems in the failure to object to certain things at trial that provides waiver. So we believe we're entitled to a frivolous appeal, as do every issue. The last thing I want to talk about is discretionary costs. The only grounds that they challenged the discretionary costs in this case on appeal, or I should say the primary ground, was the fact that the counsel did not submit an affidavit under oath that all these expenses had been done. But the case law I've cited makes it very clear that that's not mandatory. And there was, all that you need is a properly supported motion for discretionary costs. Well, they waived that issue because of the statement of issues just says the trial court erred in granting discretionary costs, and they didn't raise any particular sub-issues into that. And we think under the rules they've waived it. But more importantly, the argument they make that a lawyer's affidavit to support discretionary costs is mandatory is simply legally flawed. So we don't believe that the trial court abused its discretion in its award of discretionary costs, or abused its discretion as to any of these issues, because every one of these issues that the opposing counsel has raised in this case is based on an abuse of discretion standard of review, and they haven't met the burden. So we ask that you affirm in all respects and also award attorney's fees either under 36-6103C or attorney's fees for a frivolous appeal. Thank you.
Thank you, sir. Yes, ma'am, you have your time for rebuttal.
Yes, Your Honor, thank you. Just briefly I want to first address the issue of the attorney's fees on the $65,000, Your Honor. And to us, when you combine that with the discretionary cost and you get that total of $120,000, both of those in together were a punishment to the husband. The wife, her attorney specifically asked the trial court to punish the husband. And in our opinion, that is what happened. So we think the court did abuse their discretion in awarding those fees for the attorney's fees and for the discretionary cost. And also, when you look at the attorney's fees, they can say the husband did not prevail, but to us, the husband did prevail because he was under this structured supervised visit for a very long time. When, if you back up and look at the beginning of the case, the husband had unsupervised visits for about 20 months until Dr. Young comes in and gives this testimony and raises these concerns, and the court puts him under this supervision, which we could not get out of. There were several motions filed trying to get out from under that supervision, could not do it. The wife filed multiple proposed parenting plans requesting supervised visits. Even went so far as to file post-judgment motions asking that our offers of compromise and settlement be deemed, an offer of judgment pursuant to Rule 68, and the court found that it wasn't. But even in those, you will see it's only offers of supervised visits. So the husband had no choice but to try this case to get anything but supervised visitation. So we feel that alone should be a reason that she should not be awarded her attorney's fees. Then if you go back to the discretionary cost, it was raised in my brief, the issue about how this chart was submitted by the wife saying I've paid all these court reporter fees. There would be a date, an amount paid, and which court reporter it was paid to. But what that doesn't tell us is it doesn't tell us if that was for trial or if that was for a deposition. There was so many multiple court hearings, and at different court hearings, we had court reporters. So those are not fees that are allowed under discretionary cost. Just like the experts, you can get your fees for an expert for a deposition or for trial. But there were a lot of these fees for these experts that it wasn't specified what it was for. And that was the issue with that. So when you take those together, once again, I go back to he's paying $120,000 when he's getting a roughly $400,000 estate, because that gets back to the issue of this dissipation. And with the $20,000, that was money taken out over a period of 39 months, not just a couple of months, but 39 months. And the husband testified, hey, there was a point where I just paid for things with cash. Well, if you divide that out over 39 months, you're just a little over $500 per month. And I don't think that that is a dissipation. That might be discretionary spending. That might be ill-advised, but there's nothing in this case to show that that was a dissipation. There's even a case that they cite to where there was millions of dollars being spent and the court didn't find that a dissipation. They said that was the party's lifestyle. As to the issue raised about our statement of facts, I go back to Rule 27. It says to present a statement of the issues. That's what we did. And then the argument, we argued why we thought the trial court got those things wrong. But they cite a case called Forbes versus Forbes. And in that case, the issue presented was whether the trial court erred in not granting the wife her attorney fees. That is very similar to the issue we presented here, was whether the trial court erred in granting the wife attorney fees. The issue that the Forbes case had was that the husband raised an issue in his brief about the classification of an asset as marital or separate, and that wasn't raised in his reply brief. So that was the issue there with the statement of the case. They also cite another case, this W&H LLC versus Community Bank. And in that case, there was a lot of errors in that brief. There wasn't a table of contents. There wasn't a table of authorities, no jurisdictional statement. They didn't have a statement of issues. There wasn't citations to the record, and that wasn't what happened in this case. So I feel that we properly raised our issues before the court. They may not have been styled the way that opposing counsel thinks that they should be, but they were properly raised before the court, and they were cited to in the argument, and there was case law cited, and there were statutes cited in the argument to support those things. And I think I'm out of time. I was going to start on something else, but I don't think I can get that much out in 5 seconds. So thank you.
Thank you. I want to thank the attorneys for your presentation. Your case has now been submitted to the court, and you should receive our brief with a decision within a reasonable period of time. Thank you very much.
Thank you,
Clerk, will you kindly
Thank you, Your
recess-
Honors.
Madam Clerk, will you kindly recess court until the next calling, please?
The Honorable Court of Appeals is in recess.
The attorneys may be excused.
Thank you, Your